Uh, okay, we discussed last week up to here. So then we start from here today, the duty of secrecy. As you are aware, under the banker-customer relationship, most important duty of a bank, I would say, is this. This is called banker's duty of secrecy or duty of uh, confidentiality. So this is, you may remember, this has derived from a very uh, it's a very old concept. However, this now this concept now has been recognized under the statutory law in the Banking Act, and therefore it has become a statutory duty cast upon a bank. Now, what is the duty of secrecy? Now, remember, the duty of secrecy, initially it was not a part of banking business. As you are aware, the banking business or banking industry was established centuries back, even in Sri Lanka, right? So, as the banking industry in England, it was introduced, or it was started long years before, maybe 300 years before, right? Or at least 200 years before. So, however, the duty of secrecy, it was, as I told you before, it was not a part of banking industry or banking business. The duty of secrecy, it was basically attached to some professional services, uh, and some social services. For example, the doctors, the medicine profession or medical profession, they have duty of secrecy. The doctors cannot divulge the information of their patients without the consent of the patient to anybody. So they are duty bound to do that. They are duty bound to do that by their profession. Then when it comes to lawyers, the lawyers also cannot divulge the information of their clients to anybody without the permission of the client. Even lawyers cannot divulge that information to the courts. Now, you know that we represent the clients in courts, and we are there to safeguard the rights of our client. Now, take an example that we say someone killed a person. Then the murderer goes to a lawyer and confess the lawyer that he killed so and so. So he wants to retain the lawyer to defend him or safeguard his rights. So then the lawyer knows that person has killed another person. So information is available with the lawyer. So then the matter will fix for trial in court of law. But however, the lawyer will not divulge that information to courts. And court will never ask the question from the lawyer whether your client has killed this person or not. Because both the judges and the lawyers, they know that the lawyers are duty bound by their profession not to divulge that information to anybody. So it is the duty of the prosecution to prove the case beyond uh, uh, reasonable doubt. So that means that the prosecution has to prove that person has killed another human being. So the defendant or the accused can remain silent. Even accused lawyer will not divulge that information to anybody, and the lawyer cannot be questioned in court of law, or even police cannot question the lawyer. So accountants also, they have this duty of secrecy. They can't divulge that information of their customers or their client to anybody. So basically, Inland Revenue Department or even government institution cannot question the the auditors, or rather the accountants of a customer, and ask the information of that particular business or particular person from the auctioneers, or from the accountants or from the auditors. So that's why, that is because they are duty bound to keep that information confidential, because the customer or the client give this information to the particular professional, uh, uh, thinking that that information will not divulge to any person, and knowing that they are duty bound to adhere not to divulge that information to anybody. So that is why I say this duty of secrecy, initially it was a part of some professional services, like as I told you, doctors, accountants, lawyers, and also the priest. You know that especially when it comes to Christian or Catholic priest, uh, the people or devotees go to the priest, and they confess their, we call it sins, or they are wrong that they did. They confess to uh, uh, the priest. So priests get the information of their devotees or followers. However, they are also duty bound by their profession or by their ethics, right? It's not a profession; it's a they have ethics. So under the ethics, they cannot divulge that information. They should not divulge that information uh, to anybody else without the consent of that party. Even courts will not interfere to that and question a priest and get that information. They will not call a priest to give a information of a confession made by a devoter or a follower, because even courts or law enforcement authorities respect the duty of secrecy of a priest. So that's in that manner, this duty of secrecy was a uh, part of the other professions and other services, or social services. The people who engage in social services, they had this duty. Now, uh, how this duty of secrecy became a part of the banking industry or banking business, that we are going to discuss first, and we are going to understand that, and thereafter we will see what is the present position of the duty of secrecy. uh, we'll see. First of all, we'll understand what is duty of secrecy. What does it mean? Duty of secrecy means the banker, when it comes to banking industry, the banker should not uh, divulge information of the bank's customer. So basically, that is the basic meaning of this duty of secrecy. We are going to discuss in detail, but to understand what it means the banker should not divulge information of their customers. Then, what is the scope of this duty? Is it limited to the account information? Uh, so what at what point it is the duty starts, and at what point it is end? So likewise, what we have to see, what is the scope? Or what are the informations that we can divulge? Or what are the information that we cannot divulge? Or all the information that we have with the customer, of the customer, with the bank, cannot we divulge any information? So those are the questions that comes to our mind. So remember, this duty of secrecy is not limited only to the account details. That is one thing that I want to clear, because when I ask this question from the bankers, when I ask the question, what is bankers' duty of secrecy? The most of the bankers say the banker cannot divulge the account information of the customer to a third party without the consent of the customer. So that means they are under the impression that they can divulge other information other than the account information. So for example, as you are aware that when we are opening an account for our customer, we get a document called KYC, know your customer. Under that, we have to get a lot of information of the customer, right? So then the question is, apart from the account information, whether we can divulge information of other nature, which is not relevant to the account. So I would like to ask the question from the participant today. Can someone tell me what are the information that is covered under the duty of secrecy, and what are the information that we can divulge from the information that we get from the customer? So Rangana is there, Vidura, Rangana, can you start? What are the information is covered under the duty of secrecy? Before that, Rangana, may I ask the question? I will change the question. First, I will ask, what are the information available with you of your customer? So, for example, whether you have information of financial information, whether you have his social information, likewise, what are the information available with you?
We have his financial information as well as personal information. If it is a borrowing customer, we may have other relevant related information as well. So we have quite a lot of information when it comes to the customers who are having accounts with us.
Right. Okay. Very good, Rangana. May I say this? When it comes to banker-customer relationship, I would say you have every information of your customer. You have his financial information. You have a social information, family information. You have his health information, right? Everything is there. For example, if this customer is a credit card holder, if you analyze his credit card spending pattern, that you can you can get lot of information. And at the time of opening the account, you get lot of information under the KYC, and you get financial information, you get family or social information. Likewise, all these information are available. Now, now we say we have financial information, we have his family information, we have his social information, we have his employment information, we have his health information, right? We say types of 5 information are available with us. Now, the next question is, from those 5 types of information, what are the information that we can divulge? Or rather, what are the information that is covered under the duty of secrecy? That is, whether it's financial information, whether it is family information, whether it is social information, whether it's health information, or whether it's employment information. What are the information is covered under the duty of secrecy. Can someone answer to that question? Vidura, are you there? Or Laksana?
Yes, sir.
Vidura?
Yes, sir. I'm here.
Yeah. Vidura, what are the information now? I told you 5 types of information.
Yeah. I think, sir, all kind of information.
Right, Vidura. Why do you say the all kind of information are? Yeah, your answer is correct. First of all, right? Thank you very much. Your answer is correct, right? So why do you say it's all kind of information is covered under duty of secrecy?
Because the customer has disclosed those information to us.
Yes.
Only for us.
Yes.
That's it.
And also that customer believe that the bank will not divulge those information to the to any party without his consent. So under that impression, under that legitimate expectation, only the customer divulge that information or give this information to the bank. So therefore, the bank has a duty to keep those information in confidential manner without divulging any party. So now remember the scope. What are the information that is covered under duty of secrecy? So remember, it is not limited to the account details. Any information, this is the answer. Any information the banker received from the customer as a result of banker-customer relationship. If you get any information of the customer, whether it's from the customer or whether it's from a known party of a customer or whoever, the information that you received about the customer under banker-customer relationship is covered under duty of secrecy. Now, for example, if you are granting him a credit facility, that you do a credit evaluation. For that, you ask his employment information, or his income information, or his debt information, whether he has obtained loans from other banks. You get a crib report. Likewise, that we gather information from the customer as well as from relevant authorities or from relevant parties. So those information that we gathered of the customer are covered under this duty of secrecy. So it is very important because we have seen or we have come across situations where the bank officers, they have obtained crib reports of their customers on the request of somebody else and has given this information to those parties. We have a classical situation where there was a marriage proposal and the father of the girl has requested a bank officer who is known to the father to get a crib report of that proposed boy or son-in-law, proposed son-in-law. So that the bank officer has taken a crib report and has given that information to that the girl's father. And on the crib report, his name is there, so he has taken certain loans and leases, and so every information that about this boy has got to known to this girl's father, and the girl's father has rejected the proposal based on the crib report provided by the bank officers. Ultimately, that party got to know that his marriage proposal was broken because of the bank officers has taken a crib report. They can observe who has taken the crib report. The person can see who has taken the crib report, and that person ultimately make a complaint to the ombudsman, and the bank ultimately agreed to pay some compensation as a settlement. So this type of thing could happen, right? If you don't understand what is duty of secrecy and what is the scope of duty of secrecy. So what I advise you is not to divulge any information of a customer. Now there are situations where in divorce cases we have come across several locations. The bank officers has divulged information of the husband to the wife, or wife information, financial and credit information to the husband. So likewise, so then the party the other party whose information is divulged by the bank can sue the bank for breach of duty of secrecy. So remember, breach of duty of secrecy, under the breach of duty of secrecy, bank has to pay damages, right? Not compensation, it's damages. So damages means the bank, it could be even millions, right? So therefore, it is very dangerous situation if we divulge any information without the consent of the party. So this is a substantial principle of banking law. It's developed under the classical banking law, and it is a substantial principle. Substantial means it's a very important paramount duty or paramount duty cast upon the banker under the banking law. This has been recognized in the Banking Act, and bankers are bound by the Act. Now, remember, as I told you, this duty of secrecy, it developed in certain other professional, and it was applied to the classical banking law during this period. However, when we introduced the Banking Act in 1988, this has been now included to the Banking Act. So therefore, it is not just a classical banking under the banking law, it is now even under the statutory law, that is under the Banking Act also, it is a duty now. So it is very important that you have to read these sections of the Banking Act and have to understand what it says. Section 77 of the Banking Act says every bank officer or every bank staff rather has to sign a declaration of secrecy. So every bank staff has to sign a declaration of secrecy. So whether knowingly or without knowledge, that we all bankers, they have signed this document. So at the time of your appointment or later on, the HR department will take this declaration. So under that declaration, you are bound not to divulge any information of your customer, and you are duty bound to obey the duty of confidentiality. So that as per the section 77 of the Banking Act. Then if a bank staff breach this duty, then what happened? So that is mentioned in section 79 of the Banking Act. So as per the section 9 of the Banking Act, this is an offense. Breach of duty of secrecy is an offense. It is not just an offense. You know, the offenses that we can categorize into two categories: civil offenses and criminal offenses. Civil offenses mean that you can compensate, or you can give damages. You can grant damages, and you can compensate the offense. But when it comes to criminal liability is serious, because by paying damages, so by paying damages, you can't compensate the offense. So you will be punished. The wrongdoer will be punished under the criminal law. So therefore, it is very serious. However, as per the section 79 of the Banking Act, it says it is not just a civil offense, it's a criminal offense, it's a criminal liability. So if it is a criminal liability, what is the repercussion if you breach the duty of secrecy? So then you can be charged before a criminal courts. Then the court can impose uh, a fine up to 1 million, and also imprisonment for 3 years. So that is the danger. So we have to pay. Then if you divulge information, so the court can order to grant damages 1 million and also both, right, and also 3 years imprisonment. So therefore it is very dangerous and very serious offense, breaching of duty of secrecy. It's not just a civil offense, it's a criminal offense. So that is the basics of the duty of secrecy. Then we are going to discuss how this duty of secrecy was applied to the banking industry. So before that, if you have any concerns or any questions or clarifications from here, you can ask. Right. If you don't have any questions up to now, then we'll go to this one. This is very important. If you get a question from duty of secrecy, unless you know this case and the principle developed in this judgment, that you will not be able to get full marks and you will not understand really what the duty of secrecy and how it has developed in the banking law. So classical banking law. So this is the turning point of duty of secrecy when it comes to banking law. The case is Tonia versus National Provincial Bank. Tonia versus National Provincial Bank. This is a case decided in England. Why I say this is a turning point? This is the case that where the court decided the duty of secrecy should be applied to the banking industry or banking business, because as I told you before, it was this duty of secrecy. The concept of duty of secrecy was developed in other the professional by the other professionals or by other the areas. Initially, it was not a part of the banking business, but after this court's judgments, now it applies. After that, it was applied to the banking industry also. So what happened in the Tonia case? Tonia, the name of the customer is Tonia. He was a customer of the defendant bank, that is National Provincial Bank. Tonia had a current account with this bank. His current account was overdrawn. He has issued checks, and the bank has paid checks by overdrawing the account. So his account was overdrawn, and also the banks tried to recover the money, but Tonia didn't pay. It was the account was defaulted. He has defaulted the payment. So we say it is in NPL category now. Now, this Tonia, he worked as a salesman in a company. This company also had an account, current account, in the same bank, in the same branch. It's a coincidence, right? This bank this company where Mr. Tonia worked also had a current account in the bank in the same branch. So one day, what happened? The bank officers received a check deposited by a third party, right? A third party came, deposited a check for the payment, which was issued by the company. Which was issued by the company where Mr. Tonia worked. So the company has issued a check. Then when the check was observed by the bank, they realized the payee of the check is Mr. Tonia. So what has happened now? Mr. Tonia, the company has issued a check for Mr. Tonia. It could be salary or bonus or whatever. The company has issued a check in favor of Mr. Tonia. Mr. Tonia, what he has done, he has endorsed the check to a third party. So he has negotiated the check. Now, the holder of the check is not Mr. Tonia, is a third party. Now, that third party has now deposited the check for the payment or presented the check for the payment. So, the bank is now obliged to pay the holder the check. The value of the check has to be paid to the holder. Now, think if the check is not present, if the check is not negotiated, then the payee is Mr. Tonia. If Mr. Tonia brings the check and deposit it to his account, then the money will come to the Tonia's account. Then the bank has right to set off. So they can exercise the right to set off and recover the OD balance. Now the situation has changed because Mr. Tonia has negotiated the check to a third party. Negotiated the check. Now, when the check comes to the payment, the bank manager got annoyed, right? He knows that he can't recover the money of Mr. Tonia, and he observed the third party who brought the check to the bank is a gambling service provider. So basically, he's maintaining or he's running a club. So the manager assumed that Mr. Tonia has engaged in gambling and he has lost money. So therefore, he has given this check to the gambling service provider. So he comes and now deposit the check. So bank has to pay the money to the party. So what the manager did, because he is annoyed, he called the directors of the company where Mr. Tonia works and informed the directors about the Tonia's account. And he said that the account's Tonia's account is overdrawn and he has defaulted, he is not paying. And further, he said that the check that the company issued has given to a third party who is a gambling service provider. And further, he said that Mr. Tonia is engaged in gambling. So then the Tonia was under the contract, employments under contract. So based on the information that the company got from the bank manager, the company did not extend the contract of Mr. Tonia. So his employment was terminated based on the information got from the bank. So then Mr. Tonia got to know that his employment was terminated because the bank manager has given this information to the directors of the company. So then he sued the bank. He filed action against the bank. And his argument was the bank has a duty of secrecy. The bank has breached the duty of secrecy, and therefore that he can claim damages from the bank. From the bank side, their argument was at that time they said that the duty of secrecy is not a part of banking law. Their argument was it is banking is, as we are aware, that it is not a profession. Banking is not a profession; it's an employment. So therefore, the bankers does not have a duty of secrecy. Banker does not have a duty of secrecy. It applies only to the other professionals, not to the employees of the bank. So that was their one argument. However, then the court took a different view. Court observe what are the information available with the bank of their customers. Now, we know that lawyers, they have a duty of secrecy. So the information provided to the lawyers, they can't divulge. As we are aware, the doctors, they have a duty of secrecy. The health information is provided to the doctors. They cannot divulge that information to anybody. Likewise, the accountants, they have financial information. Auditors, they have financial information. The priests, they have social information. Likewise, those information comes to the hand of that relevant party, cannot divulge to anybody. So, that then the court looked at the information available with the banks of their customers. Then they observe the banks or the bank officers, they have all this information. They have financial information, they have social information, they have family information, they have health information, and also they have employment information, and everything. All informations are available with the banks. So then the court took a stance and said, when you get all this information of your customer, you can't say that you don't have a duty of secrecy, or you are not covered under the duty of secrecy. Therefore, you can divulge that information to anybody without the consent of the customer, and you are not bound to pay any damages because you are not duty bound to observe duty of secrecy. So that argument was rejected, and court said the duty of secrecy is a part of banking industry or banking business. So this is why we say it is a turning point when it comes to the duty of secrecy. The court accepted the duty of secrecy of bankers in this case and granted huge damage, the compensation to Mr. Tony. So thereafter, this case now is considered as a precedent case in all other cases, and this duty of secrecy has became a part of banking industry after this case, and also this case has been now followed by all other cases related to duty of secrecy. So remember, this is very important case when it comes to duty of secrecy, and you cannot and you will not be able to get the full marks unless you are well aware and well understood this the case and its judgment and the argument placed before the court at this judgment in this case. So that is Tonia case. Any questions from up to here? No questions? Okay. Then we'll go to the next one. Now we know what is duty of secrecy, and we now know what is the scope of the duty of secrecy. That means what is the area it covers. As we know that it covers every information of the customer. If that information came to the banker's hand as a result of banker-customer relationship. Now the next question that I'm going to ask or that comes to our mind, is this an absolute duty? Or in other words, under any circumstances, can't we divulge that information? Is it an absolute thing? Cannot deviate. Can we deviate from that and give this information to a third party without the customer's consent, or even customer object Are we duty bound to provide this information to any party under law or any circumstances? Can someone answer to that question? Is it absolute duty? Rangana, what do you think?
If a court order or say a government direct order comes on for a customer information, we are bound to give that without the consent of the customer.
Have you received court orders, Rangana?
Yeah,
Right. So you provide that information to whom?
directly to the court's address.
Right. Yeah. Okay. Do you get the consent of the customer, or do you inform the customer that you got a court order like this? And
No, no,
no, right?
no.
Not necessary. What are the other occasions that you provide information? Court order is one.
Inland revenue order something.
Okay. Inland revenue. What about the police? If police comes and say that we are doing an investigation and provide information to us, what do you do?
No, police has to come, get a court order and come to us. Otherwise, directly to the police, we are not allowed to give information.
Right. Okay. Others, do you agree with the Rangana's answer, Vidura? What do you think?
Yes, sir. I can agree with him.
So you agree with him?
Yeah.
So right. Okay. We'll see now. As Rangana said, as Vidura said, in certain circumstances that we can divulge information of the customer without his consent. So that means that we can deviate from the duty of secrecy and we can divulge that information. So that will not consider as a breach of duty of secrecy. So what are the occasions or what are the situations that we can provide that information? This is very important. I'm saying again, right? If you get a question from the duty of secrecy, that question will cover these points also. So basically, you have to say what is duty of secrecy. You should know how the duty of secrecy developed, and you should know what is the Tonia case and the judgment of the Tonia case and the impact of the judgment of the Tonia case into the banking industry, right? So these will be sub questions of the main questions, right? Then the fourth sub question will be under what circumstances that the banker can divulge information without the consent of the customer. So that is a fourth sub question. So basically, I gave you the question before. So it is now a matter of answering the question at the exam, right? So okay. So when it comes to that, how at what point or at what occasions that the banker can divulge information, basically there are two occasions, there are two situations the bank can divulge information. So that is, remember, one is under the classical banking law. Under the classical banking law, there are situations, there are circumstances that banker can divulge information. That is number one. Number two, under the Banking Act, there are situations that you can divulge information. So there are two occasions that you can, you are covered to give information of the customer. Number one, under the classical banking law, and number two, under the Banking Act. So remember, under the classical banking law, there are occasions that mention that the banker can divulge information. Those occasions are not similar occasions mentioned in the Banking Act. Therefore, it is very, very important to understand these two. That is what are the circumstances or what are the occasions that you can divulge information under the classical banking law, and what are the occasions or what are the occasions mentioned in the Banking Act that the bank can divulge information. So if you are covered under the classical banking act, law, or if you are covered under the Banking Act, then if you divulge that information, that will not be a breach of duty of secrecy. So we'll take first the classical law occasions that we can divulge information. So when the banker can disclose information of the customer, this slide shows under the classical banking law where the banker can divulge information of the customer without his consent. Now the first one, when the customer's consent, that is there, when the customer gives consent, when a third party requests information from the customer, if customer gives his consent, that we can divulge this information to anybody with the consent. Now, for example, the best example that I can give, that the customers, they apply sometimes visa when they are migrating or when they are go abroad. So they provide their financial information to the visa officers. Then the visa officers sometimes request or they want to clarify this information with the bank. So then in a situation like this, the customer gives instruction or customer give consent to the bank, and they provide to information. They ask you to provide the information to the visa officers. So in a situation like that, if you provide that information to the relevant party, then you are covered under the classical banking law. Then there are situations or occasions where customer's lawyer requests information for a certain reason, or customers auditors, if it is a company or the auditors, they request information. So then the customer give instruction or customer give consent to the bank to provide that information to the lawyers or to the auditors or to the accountants, right? So then we can provide that information to that relevant party or the party who requested the information. So that is number one. With the consent of the customer, we can provide information to a third party. Then number two, under the classical banking law, says when the disclosure is compelled by law, compelled in law, right? When the bank is obliged to provide that information as per the law, then we don't want to get the consent of the customer. We have to divulge that information to the relevant authority. This is very important, right? When the disclosure is compelled by law, example one, when there is a court order, when a court order issued by the court, that we have to provide that information where it mentioned in the court order to the relevant authority, that is to the court, right? That is number one. That is a common thing that we know, that as we discuss, when we get a court order, we have to provide that information. Then another example that we can give under this is a request under the customs ordinance. The customs also can, they have given the authority to request information from the financial institution or finance banks or any person under section 9 of the customs ordinance. So the custom general can issue an order to the bank or to a financial institution or any person to provide information. So then in that case, that if that order is coming in under the customs ordinance and under section 9 of the customs ordinance, if it is in the proper way, a proper manner, then we have to provide that information. If you get an order, customs under the customs ordinance or from the customs, that always get a legal opinion and see whether the order is in order to provide the information. Because we have observed some occasions, the custom officers, they write to the banks and ask information. So basically, those are you cannot say those are the orders issued under the section 9 of the customs ordinance. So therefore we have to be very careful. Sometimes they just ask as a help or as an assistance to the investigation to provide information. So therefore, such a request is not an order. So therefore, we can't divulge. However, if the order comes under this section 9, we have to provide that information to the custom because it's compelled. The bank is compelled under the law. Then request under the Bribery Commission Act. Bribery and Corruption Commissioner, or the Director General of the Bribery and Corruption Commission, can issue orders under the Bribery and Corruption Commissions Act. So therefore, when we receive the order, we have to divulge that information to the Bribery Commission. Then under the Prevention of Terrorism Act, this is very important. I asked a question from you whether the police can ask information. As Rangana said, the police cannot just ask information or request information, and we are not obliged to provide that information to the police. They have to come with a court order, that is correct. But there is an occasion that the police also can issue an order to the bank, and we are obliged to provide that information to the police without a court order. That is under the Prevention of Terrorism Act. If they are investigating a person or about a person or institution or whatever, under the Terrorism Act, Prevention of Terrorism Act, the police officer, that means the superintendent of police, right? Not any police officer, the superintendent of police can issue an order under the Prevention of Terrorism Act. So if you get an order like that, you get a legal advice, and remember, it is an order. You have to provide that information to the police even without a court order. So those are some examples that I gave you under the law, where you are bound to provide information and compelled by law. So that is number 2. Number 3, when a banker owes a duty to disclose to the public. This is under classical banking law, remember. Third occasion under the classical banking law says when the banker owes a duty to disclose to the public, then you have a duty when you are performing your work as a banker. You have a duty to provide this information to the public. So basically, you are bound to provide the information of your customer without his knowledge or consent to the general public. So then if you provide that information, then you are covered. So what are the occasions that we can think about? When a banker owes a duty to disclose to the public, can someone give me an example where you have a duty towards the general public to disclose the information of your customer? Laksara, can you answer? Oh, Vidura, Laksara, yes.
Yes, sir. Actually, I have no idea about that because since I'm not a banker,
You are not a banker. Okay.
yeah.
Right. Okay. We'll go for a banker then. What about Vidura or Rangana? Vidura, are you a banker?
Yes, I'm a banker, but I have no idea on this.
Right. Okay. So then we'll go to Rangana. Rangana, can you give me an example where the banker has a duty to disclose information to the general public?
If a customer is engaged in a illegal activity, or if a customer gets a punishment from a courts or something, in such a situation, I'm not sure of it.
Yeah, that means that when you say you have a duty to disclose to the general public, means that you publish the information of your customer to the general public. For example, you are publishing it generally, so for the entire society. So if your customer is engaged in illegal activity, or if he punished by the court of law, I don't think that you will inform all the public or general public. No,
Yes.
yeah, that is not the correct answer, Angana. So, Dilshani, can you think about an example?
So what if when I think if your client or someone is if you take it as a corporate, if they are issuing shares or debentures, and then the bank is required to give a banker's report to the shareholders or the investors.
So then, are you informing the general public?
Yeah, the investors who will be investing in it, you will
Yeah, then
be
on the request of the customer.
yeah. Then the customer would request it.
Yes, without this information we provide without the consent of the customer. Can you think a situation like that?
Also, a bank can issue their banking annual report as a macro picture of the customers.
Right, but in there you don't provide individual informations, no?
Yeah. Yes.
Right, this is not like that, right? You are, so basically the concept is the bank as a, or the banker has under the this is under conventional banking law. You are duty bound to inform the customer, rather the customer's information you are giving to the public. Basically you say that, look here, we have a customer like this and he has this much of money, and you just you put a paper article to the general public, yeah, because you are duty bound to do that. A situation like that, have you ever come across? Right, I will give you an example. Right now, for example, now think situation like Sakviti or golden key matter, right? Now think the Sakviti, now you know that he was engaged in financial, uh, I would say, scandal or whatever, right? So he took deposits from the public and he has misused that money, and the general public now coming behind him. We say now people have filed action and they are looking for his assets. In a situation like that, remember, if you so think that you have an account of this person, customer, Mr. Sakviti, right? So then that is not known to anybody. So, however, you have reasons to believe that the money lying in the account is the money that he has collected from the public. So, there's no court order, nobody knows about it. So, you can keep quiet. However, remember, as a corporate citizen and as a banker especially, you have a duty towards the society. So under the conventional banking law, if such account is maintained with you, so you can divulge that information to the general public, and the general public will get the necessary action for that. So when we say the general public, we don't publish a newspaper article or anything. So what we do, we write to the central bank or the relevant authority and we seek advice. So based on their advice, now we provide that information. For example, we know that golden key matter, the Supreme Court of the country appointed a commission to look into that matter and provide a solution. Now we say now the golden key credit card, the company, they are maintaining an account with you. Now the commission has started investigation, but there's no court order or there's no request from the commission to your bank. However, if you have an account of golden key, then you have a duty towards the public to provide that information. So therefore, you can provide that information, or you are duty bound to provide that information to that commission. So if you provide that information to the commission, the golden key directors can't come behind you and say that you have divulged that information without their consent, and therefore you have breached the duty of secrecy. So those are some examples that I can provide you, give you with regard to this. That is, the banker owes a duty of disclose to public. Are you clear on that? Okay. So then the fourth one under the disclosure, with a fourth one, when the disclosure is required in the interest of the bank. So what is this? What do you mean by for the interest of the bank? Just give me 5 minutes. Excuse me for 5 minutes. Okay, sorry about that. Okay, we were discussing about the duty of secrecy. Under that, we say that under the common or the classical banking law, the fourth occasion that we can disclose when the disclosure is required in the interest of the bank. So what is this? When we say the disclosure is required in the interest of the bank, This is the example is the previously that we discussed. When a customer, if your customer is engaged in an illegal activity, or if you see that the customer is engaged in terrorist activity or something like that, even though there is no court order, for the interest of the bank, you can provide that information to the relevant authority. This is very important, that you have to provide that information to the relevant authority. That what is the relevant authority? That if you have a suspicious transaction, that the regulator is a central bank, so that you have to inform the central bank. The central bank will provide a solution for that, or they will take necessary action. So under that, you remember that is for the interest of the bank. Now, for example, now we say, now you know that we say that there is a well-known drug dealer has an account with you, right? So you don't know that initially at the time of opening the account, you don't know that he is a drug dealer or whatever. So basically, you open an account to a customer. The customer is maintaining the account. Now the huge amount of money is in the account. All of suddenly, you see in the news that person has been arrested, right? Someone, right? Goda Polla Sunilo, whatever. Now he has arrested. Then you see that the person is a customer of your bank, right? And then what is the situation? So for the interest of the bank, since you know that the money in the account is illegally earned money, so you have a duty to inform the relevant authority about the account, because it is under the conventional banking law. The disclosure is compelled or required under in the interest of the bank. So these are the 4 occasions that the bank has to divulge information without the consent of the customer. This is under conventional banking law. So any question or any clarification you need, you can ask from here, right? If you don't have questions, then I will go to the next one. That is under the banking law. Under the banking law, what are the situation, or what are the circumstances that we can or we have to divulge information? So as per section 77, the bank director, the manager, officer, or any employee of the bank should observe a strict secrecy in respect of all transaction of the bank and the customer. So that is, it says the bank officers have to sign a declaration, a declaration of secrecy, and they have to observe this duty of secrecy strictly. But there is an exception given in the section 77. This is very important. Except, number 1, when required to do so by court of law or by the persons to whom such matter is relates. That means the customer. So when you see this, the first one, it is similar to the under the common banking law, right? Common or the conventional banking law. It says that when the customer's consent is given, or when there is a court order, the bank can divulge that information. The same thing has been recognized in the Banking Act, section 77. 7, where it says when required to do so by court of law or by the persons to whom the matter relates. That means the matter is the secrecy or the information. The information is related to the customer. So therefore, if the customer requests to do so, that means that when the customer requests to to provide that information to a third party, we can do so. And also when the court order is there, right? That is one exception given in the section 77 of the Banking Act. Then number two, it's a new one, right? This is not under the conventional or common banking law. In the performance of his duties, the banker, when he is performing his duty as a banker, if he duty bound to do that, he has to provide that information, or he can provide that information to the relevant authority. Example, right? When we are performing our duties as a banker, you know that you are bound to provide information to the central bank. When and where the central bank requests information, we provide that information to the central bank, because the central bank is the regulator or the supervisor of the banking industry in Sri Lanka. So that is when it comes to private commercial banks. What about the government banks? The government banks. The question is this: whether the bank officers are bound to provide that information if the government, not the central bank, if the government or government body or the minister requests that information, whether the bank officers of a public bank, or rather government bank, is obliged to provide that information. Can someone answer to that question? Dilshani, what do you think? If
So,
a minister requests the information from a government bank, we say BOC or People's Bank, the minister asks information, we say a minister asks the manager of or the chairman of the BOC to provide a list of opposition ministers or opposition parliament members who has taken money from BOC. Right? The minister requests from the chairman of the Bank of Ceylon, right, to provide a list of parliament members of the opposition who has obtained loans from the Bank of Ceylon. Now the request has come. The question is whether the chairman is duty bound or whether the chairman can provide that information to the minister.
I think so. They are duty bound. They can't divulge that information to the minister.
They can't or they can. They can't.
They can't.
They can't. Right.
Yeah.
Right. Or others? What do you think, Gavin? Are you there, Gavin?
Yes, even I think I don't think you should give out such information to a minister unless it's like the monetary authority or something.
Yeah, I'm okay. Think under the Banking Act, Section 77, exception of the Section 77 says, if you are duty bound to provide that information, you have to, right? The private banks, when we are performing the duty, we are duty bound to provide that information to the relevant authority. The authority is for the private banks is the central bank because they are supervising. My question is with regard to the government banks, right? Whether the government bank officer has a duty to provide that information to the bank, to the minister, right? So, Gavin, you also say the bank officer cannot. Laksara, what do you think?
Same thing. I agree with them.
Okay. Rangana, Vidura? Rangana, what do you think?
I also think we can't divulge.
Right. So, Vidura, what is your suggestion?
I also agree with them, and we are also as a government bank. They are also supervised by the central bank.
So, Vidura, are you working in a government bank?
Yes, I'm working for Bank of Ceylon.
Right. Okay. Then the question is relevant to Bank of Ceylon, right? So, the Bank of Ceylon, you said it's a government bank.
Yeah.
So, who is the authority? Or what is the authority? Who is you are the when you say you are a government bank, who is the authority who has the control over the government over the BOC?
I think we are supervised by the Central Bank of Sri Lanka.
Yeah, you are supervised by the Central Bank of Sri Lanka, and you are owned by
Uh, Owned by state ministry,
owned by the ministry,
Minister
right?
of Minister of Finance.
Minister of Finance, right? So, if Minister of Finance requests this information from the bank chairman, is he duty bound to provide that information? That is my question. Of course, I will say if the finance minister requests this information from a private bank, the private bank cannot divulge that information because the private banks, the only authority is the central bank. But when it comes to the state bank, state banks are supervised by the central bank, that is one side, and it is owned by the state. Now, what do you think, Vidura?
We also cannot disclose that.
Right. Okay. So then I will then clarify this. Remember, when it comes to private banks under Section 77, the private banks cannot divulge that information to the government. But as per the when we are performing duties, the private bank officers, they are duty bound to provide that information to the authority, that is the central bank. But when it comes to the government bank, remember the government banks are owned by the state. There are two authorities for the government banks. That is the Central Bank of Sri Lanka and as well as the line minister. Right? If it is coming under the finance ministry, the minister is the other authority. So therefore, you are duty bound to provide the information when the authority requests. So therefore, the government banks are covered under Section 77 if you provide that information to the relevant minister. Right? Now, for example, if the request come from the agriculture minister, that if you provide that information to the Minister of Agriculture, then it is a clearly breach of duty of secrecy. So therefore, you can't provide that information to that minister. Only to the line minister that you can provide that information. So remember, when it comes to the private banks and the government banks under Section 77, two different situations. The private banks cannot divulge that information to anybody other than the central bank. But when it comes to the government bank, it's different. They have to provide that information to the state also, because state is another authority where the government banks are responsible. And also, you may aware that now we have an act called Right to Information Act. Under the Right to Information Act, the Commission of Right to Information Commission can request information from the banks, especially they can request information from government banks. So then if you get a request or order from the commission, then you are duty bound to provide that information also. So that will not apply to the private banks, because the private banks are not coming under the purview of the Right to Information Act. So therefore, the government banks, you have to be very vigilant. You have to be very thorough with the law, that when you are providing, when you are following, when you are doing your banking businesses, or when you are performing your duties, there are occasions that you have to provide information that is different from the private banks. So that is number 2. Then number 3, in order to comply with any other provisions of the Banking Act or any other law. So as I told you, if there are any provisions in the Banking Act that you say that you have to provide information to anybody or any institution or any authority, then you have to provide that information. And also by under any other law, as I told you, for example, Right to Information Act or CRIB Act, or likewise then the next one is we have Financial Transaction Reporting Act. Likewise, there are so many acts where applicable to the banking industry or to the bankers, and under those acts or any law, if you are compelled to inform that information to a relevant authority, then you have to provide that information. That is also covered under Section 77 of the Banking Act. So therefore, it will not be a breach of duty of secrecy. So that is about the duty of secrecy. So any questions from the duty of secrecy that you can ask now? Okay, so then since you don't have any questions, I will briefly, I will summarize what we discussed. We discussed about the duty of secrecy. A duty of secrecy, you have to explain what is duty of secrecy. Then you should know what is the judgment and its implication on the of Tonia case, and then you should know under what circumstances the banker can divulge information. So for that, we discuss 2 law principles, that is under conventional or common banking law situation where we can divulge information, and under the Banking Act Section 77, what are the circumstances that the banker can divulge information. So to get full marks for the question of on duty of secrecy, you should be able to answer all those areas. It's not difficult. It is the only thing is that you have to read little more, and you have to understand this duty of secrecy in that such a manner that you will be able to answer to those questions. And sometimes you may get a case study also. Then you have to apply the principles that you learn to that scenario, and you have to elaborate the case, and you have to give an advice or give an answer. So that is required for your exam. So that is about duty of secrecy. Then we'll go to the next one. That is duties of care. Another duty of the banker under the banker-customer relationship. So the banker has a duty of care. The paying bank has a duty of care to protect the customer from the fraud of agents such as directors and partners in issuing checks and other payment orders. Now, as a banker, we have a dual characters, I would say. So if you are maintaining current accounts for the customers. On one occasion that you excuse me for a second. Okay, sorry about that. So we were discussing about this. That the bank has, as I told you, there's a dual character that we have when we are maintaining current accounts for our customers. We one occasion that we act as the collecting bank. We collect the checks of our customers, and some occasions that we act as the paying bank. We pay the checks of the customer. So that is how the dual character comes into picture. So when we are paying the bills of our customer, paying the checks of our customer, the bank, as a paying bank, has a duty of care. So we have a duty of care towards our customer. So we have to protect the customer from any frauds from the agent of the customer, such as directors and partners. So for example, we say our customer is a corporate customer, a company. A director of a customer, we say who is the authorized signatory of the account, has issued a check from the customer's account, that is the company account, in favor of him, right? So that means the director is taking money from the account of the company. So in a situation like that, it could be a fraud, or one partner who is the authorized signatory of the account has issued a check from the partnership account to his personal name, under his personal name. So basically, he's taking money from the account. So in a situation like that, what is the duty of ours, of the bank? The bank has a duty to observe whether there is any fraud involved, and we have a duty to protect the account holder, that is our customer, from any fraud. So therefore, before we paying such check, we have to observe, we have to make a inquiry, and we have to be satisfied that there is no fraud involved, and after that only that we should pay such a check. Then the banks also duty of care when giving financial and investment advices. This is another important point that I want to bring your notice, because the banks are providing financial and investment advices, right? Our branch office, branch staff, or even branch managers, assistant managers, they are providing advices, but we don't sometimes take that very seriously, right? We don't think that we don't realize that we are providing advices to our customers. Now, for example, there was an occasion where uh, uh, this is a real a case which was argued in District Court of Colombo, where a lady who got retired from her employment has got 3 million rupees long time back as her ETFO from the Provident Fund or whatever. She has got that from her employment at the retirement. So this lady brought this money to the bank, and she had an account with the bank, and met the branch manager and discuss and to deposit that money in a fixed deposit. Then the bank manager advised the lady, if she deposit that money in her name, under her name, in a one account, in one fixed deposit, that she has to pay the tax, because that income tax, if that income under the ceiling of income tax, that her interest will be taxed. So therefore he advised split that 3 million into 3 accounts and deposit under 3 people's name. So what she did, she took the advice and she deposited 1 million under her name, 1 million under husband's name, and 1 million under son's name. Son, he was married. Then what happened? Unfortunately, son died. So then, after the death of the son, the wife, widow of the son, claimed the money, 1 million. So then there was a huge dispute between the mother-in-law and the daughter-in-law. So the daughter-in-law said that is her husband's money, so she claimed the money. And mother said that that was her money because she got from the retirement, so she claimed. And ultimately, mother went to courts. Mother went to courts against the bank, not against the daughter-in-law. She went to courts against the bank and claimed the money and as well as damages, because the bank officers gave wrong instructions, advice. Because of that, she lost the money. So that was ultimately, fortunately, was settled, and mother-in-law and the daughter-in-law come into some sort of settlement, and part of the money given to the son's deceased customers' children, and they agreed to settle the matter. Therefore, the bank had fortunately hadn't to pay the damages. So otherwise, what will happen? That the bank has given wrong advice, actually illegal advice. So therefore, if the matter wins, the bank would have paid damages also to the account holder. So therefore, we have to be very careful when you are providing financial advisors and investment advisors, because if our advice is wrong or if it is a negligent advice, then the customer can sue the bank. Then the banks also duty of care in explaining the effect of the security documents. This is another important area that we have a duty, but we don't observe this duty. For example, I haven't seen this in the banking industry, right? Especially the bankers or bank officers, they don't know that they have a duty such like this. The banks also duty of care explaining the effect of the security documents. Now, if you get a case, you say money recovery action filed by the bank against borrower and the guarantors, the common defense that the borrower and the guarantors take in court of law, they says the bank officers never explain the security documents to them. So when we ask the question from the bank officers whether you explain the documents to the customer, the borrower and the guarantor at the time of they signing this document, the bank officer says, so why do we have to explain that? Because the document is signed by the customer, they would have read this document. Then after signing the document, why they challenge now in court of law? So that means that the bank officers, they have not understand or they don't know the banker's duty under the banking law. So one of the duty is the bank of officer's duty is they have to explain the effect of the security documents. Now, if you are taking a document, we say guarantee bond. If you are taking a guarantee bond from a guarantor, that you have to explain that and inform the person that he is signing a guarantee bond. And if you are taking indemnity, that you have to explain that the customer or the surety that you are taking an indemnity. But what is the difference between the guarantee and indemnity? That you should know before you explain it to the customer or to the guarantor. You will not be able to explain the effect of the document unless you know what it is, right? If you take a right to set off, a letter of set off, that you have to explain what is the effect of the document. Likewise, whether it is in Sinhala, whether it's in English or whatever, right? You can't say the customer knows English, so therefore he would have read the document before you sign, or you can't say the document is in Sinhala, so therefore the customer can understand that. So those are not valid arguments in court of law, because it is a duty of the banker to explain the effect of the documents when you are signing. So that is about the duty of care. So any questions from here? So if you don't have a question, then I will go to the next one. The banker's duty as a trustee. The bank is a trustee with regard to the safe custody of the deposits and goods. Now the customers comes and deposits their money in the accounts, and also if you have provided the customer safety lockers, they provide goods. They provide goods in the sense they come and keep their valuables in the safety lockers. And sometimes if you give them a gold loan facilities, the customers then pawn their gold articles, and the gold articles will be kept in the custody of the bank. So in a situation like that, remember, those goods or the properties or the deposit money is not the assets of the bank. So you are keeping that money, or the bank is keeping that money as a trustee of the customer. So the beneficiary of the trust is the customer. So you are only holding that money or the goods temporary as a trustee for the customer. So therefore, one thing, you can't utilize that, or you can't use the goods. So for example, if you take the gold articles and if you use that gold articles, that is a breach of trust, right? Likewise, that remember, the bank has a duty as a trustee for the goods and the money deposited to the account. You have to return that goods to the customer when he demands. The bank has to hold the deposits and goods for the customer on behalf of him. The bank has to act according to the instruction or the mandate of the customer. That is another important thing. When the money is deposited to the account, the goods is provided to the customer, to the bank by the customer, the bank has to follow the instructions of the customer. or the mandate of the customer. Now, for example, if customer's account is overdrawn, if customer deposited money to the current account and instruct the bank not to set off that money because he has issued a check that the money is paid to realize the check, the bank then cannot set off the money. The bank has to obey the instructions of the customer and pay the check. So therefore, if you get a specific instructions, that remember the bank has to obey, otherwise it is a breach of duty. The bank can be held liable for theft, misappropriation of the employees during the banking business. This is another important area that we have to discuss, right? Sometimes our staff, bank staff, they misappropriate or misuse the funds of the customers. There are occasions where we have observed the bank officers, they have taken the money of the customer and they use that money, and ultimately they settle the money to the customer's account. So the customer will not lose anything except the interest that could occur. So, however, whether the customer suffered any damage or not is immaterial when it comes to the misappropriation of funds of the customer. So, customer has to prove only one thing, that is the money in his account has been misappropriated or has been theft by a employee of the bank. So then the customer is entitled for the money, and as well as the customer can claim damages from the bank. So that is because it's a duty of the bank as a trustee that he has to keep that money, and the goods on behalf of the customer cannot be utilized or cannot be misappropriated by any staff of the bank. That is about the banker's duty as a trustee. So, any questions from there?
So now, if a bank is a custodian bank for one fund management to manage a fund,
Yes.
at that time they can they have the right to invest that money in some
Yeah.
places like they can buy treasury bonds or treasury bills.
Yes, yeah, that is right. That is a different contract actually. When you come into a fund management agreement, under the agreement you have certain rights. The bank has certain rights that you can utilize the money, you can invest the money, you can earn income. Likewise, there are the rights that you get under that separate contract. So that is correct, but this is under the banker-customer agreement, banker-customer contract. The banker's duty as a trustee under the banker-customer relationship, not a separate agreement. The bank has a duty as a trustee under the common banker-customer relationship. What you said is correct. When you are acting as a custodian of a, if you are enter into a fund management account agreement or something like that, yeah, you can utilize the funds. Ultimately, you have to return the money, and however, you can invest the money wherever you want. Yes. Any other questions? Right. So then, if you don't have questions, then I will go to the next one. The banker's duty as an agent. The banker is an agent of the customer for the remittance, collections of check, and payments of only on his behalf. So the banker, remember, under the banker-customer relationship, we said that is a contractual relationship, and we are discussing now the different or the different types of relationship of the banker-customer relationship, main relationship. So the bank, one times they act as the agent of the customer. So under the banker-customer relationship, it's a agent-principal relationship in certain occasions. So under this, remember the principal is the customer. Bank is the agent. It is not other way, right? So you don't think that the bank is the principal and the customer is the agent. So if it is so, then the bank is liable for the acts of the agent. But it is in other way. The bank is the agent and the customer is the principal. So whatever we do as the agent of the customer, agent of the account holder. So therefore, the account holder is liable. However, the bank has a duty. If you are the agent of the customer, the bank has a duty to obey the instructions of the principal. When we are doing remittance and collection for the customer, checks that we are the agent of the customer. The bank, as the agent of the customer, has a duty to act for the benefit of the principal, that is a customer. That is other thing. If you are the agent, you have to think about the customer's benefit. It is not the bank's benefit, it is the customer's benefit. So therefore, if any damage could happen to the customer from the remittance or from the collection of the check, you may have to think as the agent of the customer before you effect such a remittance or collection of check, whether it is appropriate to do that. So therefore, the agent has a duty towards the principal. The agent has to follow the instructions of the principal, and also the agent has to act for the benefit of the principal. That is under the banker-customer relationship. Banker as the agent and the customer as the principal. So any questions from here up to this point? Okay, so under the banker-customer relationship, we now discuss the banker's duties. So next we are going to discuss the rights and duties of the customer under the banker. Rights and duties under the banker-customer relationship. The customer's duties and rights that we are going to discuss next. So we have covered the bank's rights and duties. Next, we are going to discuss customers' rights and duties. So before we start the new topic, we'll have a short break now. We'll have a 15 minutes break. Now it is 10:30. We will start at 10:45. We will start from customers' duties and rights. We'll meet at 10:45. Thank you. Okay, we'll start. We start from here, the customer's rights and duties under the banker-customer relationship. So we'll see what are the rights and duties of the customer under the banker-customer relationship. First, we'll take the customer's rights. So customer's rights under the banker-customer relationship. Now, when we now already we discussed, the customer means the person who has opened an account with the bank. As soon as the customer open an account, as soon as a person open an account, the banker-customer relationship starts, and we consider that person as a customer of the bank. The bank customer and the customer of others, like shop customer, the office customer, those customers are different from the banker's customer, because between the banker and the customer there is a contract, the contractual relationship. So customer, when a customer open an account, customer gets certain due rights under the contract. by opening an account, he gets certain rights. So what are those rights? Number one, the customer gives a mandate to the bank, and the bank has act according to the given mandate. So that is important. The rights that the customer has, and the obligation from the bank side. Customer gives a mandate to the bank. Bank has to obey the mandate or act according to the mandate given by the customer. So that is that first right of the customer. So the question is, what is a mandate? What is the definition for the mandate of the customer? So Vidura from Bank of Ceylon, can you give an interpretation for the mandate? Vidura, are you there?
Yes, Amit.
Yeah, Vidura, what is the definition for the mandate?
It's customer instructions and is information.
So customers' instructions and information. No, not the answer I expect. I want the legal definition that we can give for the mandate. Mandate.
It is the agreement between the bank and the customer.
Agreement between the bank and the customer. No, Vidura, still not the correct answer. Dilshani, can you give an answer?
So the mandate is like authority or like a set of instructions given by the customer to the bank.
Yeah, you are there. Now,
Carry
yes.
out transactions and all.
Yeah. So I would say 80% or 90% of the answer is correct. Right? Now you said authority or the instructions. So can we be more specific, more precise? What is mandate? I said 80% is of the answer, or 90% rather. The answer is correct. Can someone else try, or even Darshini? Sorry, Dilshani can further specific, precise on the what is the definition that we can give? What is actually mean by mandate? So your answer, I said 90% is okay. Anyone else want to try? Pulit, are you there? Okay, right. Since others are not willing to, sorry. Right. So the mandate is the authority given by the customer to the bank to operate his account on behalf of him. Right? The mandate means the authority given by the customer to the bank to operate his account on behalf of him. Now when we say customer open an account, as we discussed previously, it is the customer's account. The customer has the right to operate the account. So if customer has a right to operate the account, no one else has the right to operate his account unless he gives authority. Now, for example, it's like this now. So I have a wallet, right? I have a wallet. So I put money into my wallet. So I am the owner of the wallet. I have the right to operate the wallet, right? I can put money into my wallet, I can take money from my wallet. So if we say the account is also similar to a wallet, the wallet is belongs to a customer. Likewise, the account is belongs to the customer. So the who has the right to deposit money and withdraw the money? It is the customer. But actually speaking, who is operating the account? So we don't allow the customer to operate the account, even though we say the customer operate the account, unless it is on the mobile banking and internet banking. Now the customers has given that opportunity to operate his account online, but it's not 100%. However, on behalf of the customer, the bank officers or bank staff operate the account. When a customer wants to deposit money, if he comes to the branch and if he deposit the money, he has to fill the deposit slip, and he has to hand over the money to the teller with the deposit slip. The teller will go into the system and operate the account and will deposit the money. Right? If a customer comes to the branch and he want to withdraw the money, it's the same scenario. So the teller will operate the account and take the money from the account and give to the customer. So basically, it is the bank staff who operate the account. So then the question is, if the account belongs to the customer, what is the authority that we have to operate others' account, other people's property? So it's a customer's property. So where do we get that authority? So we get this authority at the time of opening the account. Customer signed a mandate and give to the bank. So that mandates give the authority to operate the account of the customer. Right? So the definition that we can give to the mandate, it is the authority given by the customer to the bank to operate the customer's account on behalf of the customer. So that is the mandate. So when we say the mandate is the authority given by the customer on behalf of the customer, it means the bank has to obey the instructions or the mandate of the customer. So bank has to act according to the given mandate or given instructions. So we have a classic case here. It's a Huron Bain versus Federal Bank of Australia. So it's a good example that we can discuss with regard to the following instructions of the customer. So what happened here? This customer's account, he had an account, current account. That account was overdrawn. So we know that when the account is overdrawn, if customer deposit money, what will happen? The money will absorb against the OD balance, or we say we will set off the OD balance and we will reduce the OD balance by absorbing the money deposited to the account. So in this case, what happened? His account was overdrawn, so that means he owed money to the bank. However, he deposited some money to this overdrawn account. And he deposited money to the overdrawn account with specific instructions. This is very important. Specific instructions. He gave specific instructions to the teller. So he said the money was deposited to meet a check which could be presented to his account. So by that time he has issued a check. So that the check will in future day, the check will come to the account for the payment, for the realization. So what he did, he deposited the value of the check into the account and gave specific instructions to the teller and said, this money is to meet the value of the check. So therefore, don't set off the OD. This is to pay the check. So then what happened? The manager, without informing the customer, set off the OD against the deposit So what happened? The manager, against the instructions of specific instructions given by the customer, without informing the customer, he set off the money against the overdraft. So then what happened? The check got returned. Check came and check got returned because there is a insufficient funds in the account. Then the customer sued the bank. Customer sued the bank and said the customer's right has been breached, violated by the bank. So under the banker-customer relationship, he has a right to give specific instruction, and the bank has to follow the customer's instruction or the mandate. The bank has failed to do so, and therefore they have breached the banker-customer relationship contract. So therefore, he sued the bank and asked damages. So what was the decision of the court? It was held that the bank has no right to set off the bank, and the bank has to abide by the instructions of the customer. It was decided against the bank. The court said when a specific instruction is given, the customer has a right for that, and bank has a duty to obey the instructions of the bank. So in this occasion, the bank has not obeyed the instruction. Therefore, it is a clear breach of duty. Hence, the bank is liable for the breach of contract. So that what happened, and this is a classic case that we can show with regard to the rights of the customer to give instructions to the bank, and the bank's duty to honor the customer's instruction. So any questions from this one? Banker's right to open an account. When we say right to open an account, it is not a right that he has to open the account, but if we allow the customer to open an account, he gets certain rights. That is meant by this. Any questions? Okay, if you don't have questions, then I will go to the next one. The customer's right, the second right of the customer to stop the account. Customer has a right to stop the account. Now, when we say stopping the account, remember, don't mix this up with closing the account. Closing account and stopping account are not same, it is different, right? Customer has or can seize the debits and credits of the account until further notice. This is called stopping an account. The customer has a right to.
Hello, sir.
Yes.
On the previous one,
Yes.
previous slide, in that slide, how it matches with the banker's right to set off, is it not applicable here?
Yeah,
I mean,
good question. It's a very good question. In fact, that is this Rangana, no? Rangana, yeah, that I actually waited for those questions, but unfortunately you didn't ask. I mean, others didn't ask. So these are the things that you have to, think. Now, one side, the previously under the banker's right, I said the bank has a right to set off. Right to set off means the bank can set off two accounts of the customer or customer's money that you can set off against the dues to the bank. That is a right of the bank. And on the other side, from under this customer's right, I said the bank, the customer has a right to give specific instructions to the bank, and the bank has to obey the instructions of the customer. Now these two, if you take together, is a contradicting thing, because one side the bank has a right to set off, and the other side, customer has a right to give specific instruction. Then the bank cannot set off. So what is the legal situation? So how do you address this issue? So remember, Rangana, it's very interesting. Bank has a right to set off. There's no doubt of it. But that right is restricted when the customer gives specific instructions. Clear? I believe that you will realize that the right to set off is subject to certain conditions. As we are going to discuss later in detail. However, if I say briefly, the right to set off you can exercise if one customer maintain more than one account in the same capacity, and if there is no specific instruction. But here you see, when a customer gives specific instruction, that is his right. The bank's right to set off will be superseded by the instruction of the customer, specific instruction. So bank's right to set off can be exercised unless there is a specific instructions of the customer. So are you clear with that
Yes.
answer?
Yes.
Yes. Thank you for that question. So that is the thinking line that I want you to apply. So just don't take the what I said. You think you argue with what you learn. So think how this could happen. What happened if this happened? Likewise, you have to argue. Then only you can learn this thing. The law. Law is something that you have to argue and learn. So, any other questions from this one?
So I have a question.
Yes.
When the account is overdrawn and it is in the NPA section, can't we get the bankers right to set off? Can't we execute the right of the bankers?
So you say that when the customer's account is in NPL category, that means the customer is default and he has not paid properly, whether you can exercise right to set off.
And he's also giving the specific instructions to pay the check and deposit money on what we are going to do, sir.
Right. So the customer is in NPL category, customer deposit money and give instructions, specific instructions to the bank.
Yeah.
So
Yeah.
your question is whether we can, in a situation like that, whether we can exercise our right to set off.
Yeah.
Yes. Again, I say when the customer gives specific instruction as per this judgment, Nuremberg versus Federal Bank of Australia, the bank's right to set off will be superseded by the customer's specific instructions. So therefore, the bank cannot exercise the right to set off unless there is a set of irrevocable, unlimited letter of set off. So if there is a letter of set off given by the customer previously, that will supersede that will get the priority. So otherwise, what will happen when a customer gives specific instruction, the specific instruction will get priority, and the right to set off will go go down basically. So that is the answer. Are you okay with that answer?
Yes.
Okay. So any more questions, or shall I go to the next one?
There's a small one. So,
Yes.
say the specific instructions. If a customer gives a specific instruction to overdraw the account, whereas we are not allowed to do so, we can decline that request, no?
It's not clear. Your question is not clear. Can you repeat the question?
Say a customer specifically requests the bank to overdraw his account.
Okay, right.
So in that case, decision is on our part. We can decline that. No?
Yes. So the customer can't give us specific instructions to overdraw his account. That is a credit decision that we have to take, the bank, right? The customer can give specific instructions up to the credit limit of his account. So if he has money in his account, he can give instructions to the bank how to appropriate that money. If there is no money in his account, the customer can't give a specific instructions to the bank to overdraw his account or overdraw his account and pay. That is a credit decision. That is a discretion the bank has. That is a bank's right. So therefore, he has the right to give such instruction. However, if the customer's account is overdrawn, whatever the reason, the bank may have taken decision and has paid his checks and has now overdrawn his account. Still, the bank, the customer can give specific instruction for the money he deposited to the account, right? So, so that when he is depositing money, he can give specific instructions to the bank not to utilize that money or you appropriate the money to recover the OD, right? And utilize that money to meet the check in this case. And also in the same time, we say the customer has taken several facilities. We say he has a loan facility and he has a overdraft facility. We say the loan facility, he has a housing loan facility, which is secured by a mortgage bond, and he has an overdraft facility. It's a clean facility. So what we observed is when such a scenario, the customers they are willing to pay the home loan because they know that if it is go bad, the bank can auction the property. So therefore, what they do, they deposit money to the loan account, or they deposit money to the savings account and give instructions to the bank to appropriate that money to the loan account, not to the overdraft. So in a situation like that, whether we can exercise our right to set off and we can recover the whatever the loan we owe the OD as we wish. The answer is again the customer's instructions that we have to obey unless there is a contradictory agreement. So where at the time of you granting the loan, if you take an agreement or a clause, if there is a clause in the agreement to say that the bank has a right to appropriate the money deposited by the customer as bank wish, then you can utilize that money to recover the OD. Otherwise, if customer deposit money to his savings account and instruct the bank to recover the loan, then the bank cannot recover the overdraft instead of the loan. So that is his right to give specific instructions. So I hope that is clear. Any other questions? Okay, so then I'll go to the next one. We were discussing about the stopping an account. As I told before, stopping account and closing account are not the same, not similar. It's two different things or principles. The stopping account means the customer can stop or cease the debit or credit of his account until further period, until further notice. So when you see this, customer can give instructions to the bank by stopping the credit and debit, that means the operation of the account, for a period of time. So it is not a closure of the account. So basically, this is a temporary thing. It's not a permanent thing, right? It's a temporary for a period of time. For a temporary period of time, the customer can instruct bank not to operate the account, debit and credit. Closing an account is a different thing. Closing an account means the customer has a right to close the account and it is a permanent thing. It's not a temporary thing. It's not a period of time. It is when account is closed, it's closed forever. that is the difference between the stopping an account and closing an account. So, for example, sometimes if a customer observed any doubtful transaction in his account, or if he suspect any fraud has happened or had occurred in his account by his agent or by his staff or even bank staff, in a situation like that, customer can give instructions to the bank to stop the account for a certain period of time or until further notice, enable him to reconcile his account. Right? For example, if I observe some doubtful or suspicious transaction in my account, I immediately, what I will do, I will give instructions to the bank to stop the account. Stop the account means debit and credit both has to freeze. And then thereafter, I will reconcile my account. I will go through my the account details and I will see so whether that transaction reported in my account statement, whether those are correct or whether any fraud or any misappropriation have been happened, and then so for that I want to stop the account for a period of time. So if I give such instructions to the bank, then the bank has to obey that instruction and has to stop debit and credit both of the account. When you say the debit and credit, that means the account is basically stopped. Then the bank should immediately stop the account once the mandate is revoked. So when the customer says stop my debit and credit, that means the bank has no right to operate the account. So the given mandate or the authority is taken back by the customer. So as I told you before, the mandate means the authority given by the customer to the bank to operate his account. So now he has taken back that authority. So therefore, the bank cannot operate the account of the customer. So then, the bank should not honor any checks or pay any standing orders during this period. If you receive the stop account instructions, so during that period, whatever the checks that he has issued before will not be paid. So you have to return the check. So you can say account stopped and return the check. And also standing orders given by the customer during this period will be not honored. So that means the money will not pay. Then the bank can debit the account only for the recovery of loans, charges occurred before it received the stop notice. This is very interesting, right? Very important also. When a customer gives instructions to the bank to stop the account, the bank cannot do any debits or credit. However, subject to one condition. What is the condition? Bank is entitled to charge the interest or recover any losses or charges from the customer's account if that charge or interest or anything, any due has been occurred before the bank received the stop instruction. Now, for example, we say the customer's account is overdrawn. It's OD, it's got overdrawn, and the customer immediately give instructions to the bank to stop the account. Now, as we know, once the account is overdrawn, the bank charge interest. Normally, what happens when the account is overdrawn, the interest accumulate and the interest will be hit to the account at the end of the month. So we say the account got overdrawn on the 5th of the month, 5th of January, and the 6th of January the customer give instructions to stop the account. Now the question is whether we can charge interest for this period. So as per this, yes, the bank has right to charge interest at the end of the month the bank can debit the interest to the account. So otherwise, the bank cannot operate the account only for that purpose, only to charge losses and charges and interest, those things that we can operate the account. Other than, no transaction can be done when the account is stopped. The banker-customer relationship, what will happen? If the account is stopped by the customer, what will happen to the banker-customer relationship? So the answer is, stopping the account is not a permanent thing, it's a temporary thing. So therefore, the banker-customer relationship prevails. It is valid. The contract is still valid. So therefore, the all rights and duties between the parties will exist. Agreement prevail. Once the customers give instructions to restart the account, then the bank can operate the account. Or if customer has given instruction to stop the account certain period of time, at the expiration of the period, then the bank can operate the account and debit and credit the account. So that is called customer's right to stop the account. So if you have any questions from stopping an account, you may ask now. Are you clear what is stopping an account? The legal position once the account is closed, the rights of the parties when the account is closed. So those things that you have to think about. So if you don't have questions on stopping an account, then I will go to the next one. That is customer's right to close the account. As I told you before, the closing an account is not the same as stopping an account. Closing an account is as I told you before, it's a permanent thing. Once the account is closed, it cannot be reopened. Right? It's a permanent thing. Customer has a right to close his account. That is a very important thing that we have to remember. Customer at any given time, without prior notice, can give instructions to the bank to close his account. As we are aware, it is different from the bank's side. Bank wants to close the account, as we discussed. Bank also has a right to close the account of the customer without his consent, but we have to give prior notice. We said that if it is a savings account, we have to give prior we have to give prior notice, and we have to give adequate notice to the customer. So how do we decide the adequate time that we discussed last occasion? So here, when it comes to the customer's right is different. Here, the customer does not want to give any prior notice to the bank. At any given time, he can just come to the bank and give instructions. So bank has to obey with the instruction. The customer-banker relationship, what happened to that? Once the account is closed, the banker-customer relationship comes to end. So thereafter, no banker-customer relationship. So that means the rights and duties of the parties will come to end. So thereafter, you have no right against the customer, and the customer has no right against the bank. Except one thing. What is that? That is duty of secrecy. Duty of secrecy is an exception to the contract, law of contract. Law of contract, under the law of contract, once the contract is over or contract is terminated, the rights and duties of the parties also comes to end. However, under this one, the duty of secrecy will not end even the account is closed. So that you have to remember. So excuse me for a second. Right, sorry about that. Uh, however, once the account is closed, as we discussed, the duty of secrecy will be not over, will be not end, even the account is closed. So remember, after closing the account, also the bank has to obey the duty of secrecy, and it will not end even the account is closed. So basically, we say once the duty of secrecy start at the point of opening the account, but once the duty of secrecy is started, it will never end. So therefore, the bank has no right to divulge information of the customer, even though the account is closed, even though the account is overdrawn, or even the customer is deceased. So this we have to remember, the the duty of the bank, as a duty of the bank. So closed account cannot be reopened. There's another important thing, as I told you before. The the account closing of account is a permanent thing. It's a permanent thing. So therefore, once the account is closed, it cannot be reopened. So basically, you cannot allocate the same account number to the customer in a future account. So for example, customer can close the account today and he can open another account tomorrow, but he can't reopen the same account. So the same number you can't allocate once, because the contract is over. The bank and the customer can create another contract, but it is a different contract. It's a different bank customer relationship, not the same. It's not a continuation of the same relationship. So important thing, it's a very interesting and also important thing that you have to remember. Though customer has a right to give instructions to the bank to close his account at any time without prior notice, the customer can give that instruction verbally. It is not necessary to give instruction in writing. However, this is very important. However, the bank is always, we advise the bank to get that instruction in writing. Though the customer give instruction verbally, that we have to get that instruction in writing. We have to obey the instruction of the customer. We have to obey the verbal instructions of the customer. However, you have to follow it up and you have to get that instruction in writing. So there's a very important case here, that is Wilson versus Midland Bank. In this matter, what happened? Mr. Wilson gave instructions to the bank to close his account. He had a current account. He gave verbal instructions to the bank to close his account. Ultimately, what happened? So the bank obeyed the instruction and got the verbal instruction and closed the account. Anyway, the bank didn't follow up and got the written instruction from the customer. So later on, all his checks got returned, and afterwards, Mr. Wilson said that he filed action against the bank, and he said he never gave instructions to close his account. So therefore, his reputation got damaged, and he claimed damages from the bank. So the advice that I can give to the bank is, though you have to act, or though you have to follow the instructions of the customer, verbal instructions of the customer, it is always better, always advisable to get that instruction in writing. So this thing apply even for the stopping and check, stopping of a check or countermanding of a check, right? Customer can give instructions to the bank to stop a check. So he can give verbal instruction. He can call the branch and inform the branch to stop the check. So you have to accept the instruction, verbal instruction, telephone instruction, or telephone instruction. But again, remember to get that instruction in writing, because if customer deny, we should have a proof to show to courts that we received the customer's instruction. So that is about closing of an account. So if you have any questions from this slide, that you can ask, if you have any question about the closing of an account. Any questions?
So if there's like some sort of financial crime or something involved, like does the bank still have a right to like close the account, seize the account without the customer's consent, or like do we have to usually request for the customer to exit?
Can you explain the question again? If there is a financial crime or fraud occurred in the account,
so then even then, like do we have to like, as a bank, do we have to like request the customer, like you can like straight away seize the account?
Yeah, good question. Very good question, right? In a situation like that, right? We have observed the customer has violated the agreement, and customer has done any fraud or has engaged in illegal activity. The question is whether we still need to give notice an adequate time to the customer to close the account. Answer is this: if you observe any fraud, any illegal activity of the customer's account, there's a procedure to follow. That we have to immediately inform through the compliance department, that you have to inform the central bank, and you have to follow the instructions of the central bank. That is number one. Number two, you have a right to prevent any fraud of the customer's account. So in that manner, under that duty, the bank has a right to immediately seize the customer's account for the benefit of the customer. So and also for the benefit of the bank, to protect the interest of the bank. So you can immediately seize the account. Then the next thing that you have to do, you have to send a notice to the customer, informing the customer that you have taken a decision to close his account, and you have basically in a situation like that, it is a special scenario that you have to give again. You just can't close the account and send the notice. You better freeze the account and send notice to the customer, informing the customer that you are closing the account within a reasonable time. But basically, if there is a fraud or if any misappropriation of funds or anything has happened, it is not advisable to close the account, because then you have to go to if you go to court. So if the banker if the customer go to courts, then if you close the account, there can be there can be problems, because then sometimes you can't see the previous transaction of the customer. So best thing is to seize the account and keep the account open. So you can freeze the account, debit and credit you can freeze, and until that that we get a legal clearance from the court of law, we can keep the account without closing the account. And if you want to close the account, then need not to give such a period to the customer. We can give a reasonable notice, say 14 days, and then after that we can close the account. So that is when there is a fraud or illegal activity involved in a account. Hope that will clear your answer, your question.
Yes, sir. All right.
Yeah. Any other questions from the closing of an account? Right. If you don't have questions from there, then I will go to the next one. So then I will go to the fourth right of the customer, right to interest. Customer has a right to interest, right to claim interest from the bank. Number one, for the deposit accounts, customer receive interest. For example, savings account, fixed deposit, NRFC, RFC, these types of accounts, the bank give interest for the deposits. Then if you have agreed to pay a certain percentage of interest rate, the bank has no right to change the interest during the period. For example, if bank has agreed to pay, we say 5% for a fixed deposit for a 1 year, during the 1 year period, the bank has no right to change the interest rate. But for the savings accounts and other accounts, other than the fixed deposits, the interest rate can be changed based on the market condition. So the rate of interest fluctuate in line with the prevailing market rates for the other accounts other than the fixed deposits. In special types of account, the bank has no right to change the agreed interest rate. Special type of account means the fixed deposits account. The bank has no right to change the interest rate without the consent of the customer during the period the account is open, or during the period before the expiry of the period. So therefore, remember, the customer has right to claim the interest for the accounts if we have agreed to pay the interest. As everyone aware, for the current accounts, we don't pay interest. That is a banking practice. So other than the current accounts, all other accounts, if the bank has agreed to pay interest, that interest customer can claim. So again, there is a case that we have to remember. This, I think, we discussed previously also, that is Foley versus Hill. In this matter, it was decided once the money is paid to the bank or deposited in the bank, the money is no more the customer's money. The bank has a right to use that money. The bank can use the money in the way the bank wants, and bank can invest the money, or bank can lend the money, and bank can earn income. The bank is only answerable to the customer to repay the amount deposited when the customer demand. That is the only requirement. So So then that is about the interest. Then the next one, right to draw checks. Customers has a right to draw checks from his current accounts. The current account holders have an implied right to issue checks. The bank has an implied duty to honor the checks up to the limit of the credit balance. The customer can deposit checks to his current account. So these are relevant to the current account holders. When we allow a person to open a current account, there are certain implied rights and duties applicable to the current account holders. Now, for example, the current account holders have an implied right to issue checks. As everyone aware, the current accounts are operated by issuing checks. We give a checkbook or check leaf to the customer to operate the current accounts. So you can't have a current account where you have restricted the customer to issue checks. So that is not possible because it is a right of the customer to open, to issue checks if it is a current account. So then, on the other hand, there is no meaning of issuing checks or allowing the customer to issue checks unless the bank accept the checks and pay the checks. So therefore, the bank has implied duty from the bank's side. They have a duty to honor the checks issued by the customer. So that duty is to honor the checks up to the credit balance. So if there is money, sufficient money in the account, that bank has a duty to honor the check. So the customer can deposit checks to his current account. So customer, if we have allowed the customer to open a current account, the customer can deposit the checks that he received from others to his current account. That is also another implied right of a current account holder. So that is called right to draw checks. So there is a case that we have to remember here, that is a Joachimson versus Swiss Bank Corporation. So I believe that we discussed this also. The customer has to make a demand to repay the money, and the demand has to be made to the same branch and during the banking hours. This is relevant to a issuance of a check. So customer has to make a demand to repay. So as we are aware, the customer can deposit money to his account, and bank has a duty to repay the money when the customer demand. So in Joachimson versus Swiss Bank Corporation, it was decided to pay the money, the customer has to demand the money. So bank has a duty to pay the money when the customer demand. So therefore, customer has to demand. If it is a current account, customer has to make a demand by issuing a check. So he has to issue a proper check, a valid check. That is number one. Number two, the check or the demand he has to make to the same branch where he maintains the current account. That is one condition. And the check has to be presented for the payment during the banking hours. Those are the conditions mentioned in the Joachimson versus Swiss Bank Corporation Limited. So you can see this case has been decided in 1922. So by that time, this computer system or the bank branch system was not joined or integrated by a computer system. All those days, the bank branches operated separately and isolatedly, so they were not connected to each other. So therefore, this judgment is valid for that period. So now we know that the banking system, the technology has been changed. Now we have a system, the computer system, where we can connect all the branches of the bank together. So that is called banking system. So therefore, it is not necessary to deposit the check in the same branch now where the account is maintained. Even the check is presented to a different branch, that branch can view the account of the customer and can pay the check. However, as we discussed before, that is an extra service that bank provide for the customer. Therefore, the customers cannot demand for the payment from a different branch. However, it is possible. So the customer has anyway right to draw checks from the current account, if we maintaining a current account in the bank. So that is about the customer's right to draw checks. So if you have any questions from here or from the previous one, that is for the interest, customer's right to interest, do you have any questions? Okay, if you don't have any questions from those two slides, then I will go to the next one. Next, we are going to discuss another important area. So that is the duties of the customer under the banker-customer relationship. Duties of the customer under the banker-customer relationship. So we discussed the right of the customer. Now we are going to discuss the duties of the customer. First one, duty of reasonable care. The customer has a duty of reasonable care. You may remember under the banker's duties we discussed, the banker also has a duty of reasonable care, duty of care. The customer side also, the customer also has a duty of reasonable care. What is the duty of reasonable care? Where the customer has to observe. The customer has an implied duty to exercise reasonable care when he gives written orders or written instructions to the bank, so that not to mislead the bank or facilitate for a forgery. This is very important. Again, remember, this is an implied duty. Implied duty means it is not written in anywhere. However, it is applied. It applies to the customer. It is called reasonable care. Customer has a reasonable care when he gives instructions to the bank. Instructions or orders. Written instructions or orders to the bank. What are the written instructions customer give to the bank? So mainly the most common written instruction or written order the customer gives is the check. Customer, the current account holder, give written instruction or written order to the bank to pay certain sum of money by way of a check, right? That is the common one. Or sometimes customer give instructions to transfer money. Likewise, the customer can give written instructions to the bank. So when he give written instructions to the bank, he has a duty to give that instruction in a manner not to mislead the bank. Number one. So that means the instruction must be very clear. Unambiguous, clear instruction must be given. So otherwise, the bank can get misled. So if bank get misled by the instruction of the customer, the bank is then not liable because the customer has breached the duty of reasonable care. That is number one. Number two, the customer has a duty to give clear instructions to the written instruction to the bank, which should not facilitate for a forgery, right? If customer is negligent and if he has not given, if he has not paid proper attention or reasonable care when he is giving instruction, which has facilitated, the instruction given by the customer has facilitated for a forgery, then if damage has happened to the customer, the bank is not then liable for such damage. So that is number one, the duty of reasonable care. So we have a case here that is London Stock Bank versus Macmillan and Arthur. This is very interesting and very important case when it comes to reasonable care. This is known as the Macmillan case, or the theory or the theory or the judgment, the law theory introduced by this case is known as the Macmillan theory. Macmillan case, Macmillan theory is the same, is the reference given to this case, same case. London Stock Bank versus Macmillan and Arthur. What happened in this matter? This account holder, a current account holder, he issued a cash check. So the check was for £2. £2. So what he did, as we are aware, when we are writing a check, there is a space. There are 2 spaces in the check to write the value of the check. So you have to write the value of the check in words and as well as in figures. So what happened? This person, he wrote the cash check, and he didn't write the value of the check in words, but he wrote the value of the check in figures. In the space where he has to write that, he wrote the value of the check in figures. He put £2 in figures and signed the check and gave this check to a third party. So this third party, what he did, he got the check, he altered the check. So what he did, he put 1 before the 2 number and 0 after 2. So now it has been altered. Now the value of the check is 120. He put 1 before 2 and 0 after 2. So then it is altered as a 120. And also wrote the value of the check in words as £120. And he presented the check for the payment of the bank. Right? He presented the check for the payment, and the check was paid from the customer's account. And the customer realized that a check has been paid for 120. Instead, he remembered that he wrote the check only for £2. So what he did, he filed action against the bank. So his argument was, it is an altered check. So when the check is materially altered, the bank has no right to debit the customer's account. The check is invalid, so therefore bank has no right to pay the check from the customer's account. And if it is paid, it is a mistaken payment, then therefore the bank has to return that money to the customer. So that is his argument. From the bank side, then what happened? The customer sued the bank, and he claimed the money, the value of the check from the bank. So remember, this £120 in this it's a very old case. At that time, it was a huge amount. So he filed action and he sued the bank. Now his argument, it is a altered check, materially altered check. So therefore, bank has to return the money. So the bank's argument was, the bank, under the banker-customer relationship, the customer has a duty. Customer has a duty of reasonable care. When he gives instruction, he has a duty to write the instruction to avoid any forgery. Or in other words, he should not give instructions to the bank which facilitate for a forgery. Now, the manner this customer has written the check has facilitated for a forgery. Now, when we say check is a written instruction from the customer. So he gave written instructions to the bank to pay £2 from his account. But however, the way he wrote the check, because he didn't write the value of the check in words, and also he just kept space after he wrote the value of the check in figures, he kept a space. before the pound mark and after the 2. So that's why the third party was able to alter the check. So therefore, it is very clear the customer has given instructions very negligent manner. So he basically has not observed the duty of reasonable care. So that was the argument of the bank. So then the court in this matter held with the bank and said the customer has breached the duty of reasonable care under the banker-customer relationship. So therefore, the bank is not answerable or responsible for the damage or the loss occurred to the customer because he has breached the duty by giving instructions which facilitate for forgery. So therefore, customers the claim was unsuccessful. So that is called Macmillan theory or Macmillan case. So that is number 1. So any questions from duty of reasonable care of the customer? If you have any questions, you can ask. Any questions? Okay, if you don't have any questions, then I will go to the next one. This is another case decided in Sri Lanka, 59 NLR. It's reported in 59 NLR 190, decided in 1957. Kulatilaka versus Mercantile Bank of India. So in this matter, 2 checks were drawn by the customer, were subsequently fraudulently altered by the customer's clerk. So this customer, the account holder, he has a clerk. The checks issued by the customer has been altered by the clerk of the customer and has got cleared from the bank. It was in evidence that the customer was not able to write in English the amounts and the other particulars of the check. All he could do was sign them. So the person, the businessman, he couldn't write in English. So what he did, he just signed the check. But the clerk is the person who wrote the check in English and got the money. So then it was realized, or it was evident by in court. So it is not the person, it is not the customer who wrote the amount. So it is the clerk who wrote always, and the customer only signed the check. So then the Supreme Court exonerated the paying bank from the liability of the accepting and paying the forged checks and held that it was entitled to debit the customer's account with the full amount of the excess sum. So what happened in this matter? The customer, the account holder, later realized that his checks were altered. Checks that he signed has been altered and forged, and the money has been taken from his account. So then he filed action against the bank. So at the trial, it was evident that he cannot write the figure or the value of the check in English. He only signed the check. It's the clerk who has altered the check. So therefore, the way that the customer give instruction has breached the duty of reasonable care. So therefore, the damage occurred to the customer has to bear by the customer. The bank is not liable for such damage. So that was the decision of the court. So any questions up to here? Right. If you don't have question, then I will go to the next one. The second duty of the customer, duty to disclose forgeries. Duty to disclose forgeries. This is another important duty of a customer under the banker-customer relationship. The customer has a duty to disclose forgeries of his account to the bank. The customer has an implied duty to inform the bank if he disclose any forgery about checks or accounts. So this is that you have to remember this. The customer, the account holder, has a duty to, it's an implied duty again, he has a duty to inform the bank, at the first occasion, that he discover any forgery of his account or any checks of his account. So that is a duty. So there is a case again, a very important case, which is known as Greenwood versus Martins Bank. This is known as a Greenwood case, or the law principle decided in this matter was known as Greenwood theory. The previous one, you may remember, it is known as Macmillan theory. This is Greenwood case, and the theory discussed here is known as Greenwood theory. What happened in this matter? Mr. Greenwood had an current account in this bank. So he had a checkbook. He kept the checkbook at his home. So then one day when he go through his current account statement, he observed that certain number of checks has been paid from his account where he has not issued, or rather he has not signed. So he realized that certain number of checks that has been paid from his account. So therefore, then what he did, he checked his checkbook, and then he realized someone has forged the signature of Mr. Greenwood and has taken money from his account by issuing checks. So then he inquired about this from his wife. Then wife accepted that she forged the signature of Mr. Greenwood and got money from the Mr. Greenwood's account. Now, what happened? What has happened here? There is a clear forgery. Someone has forged the signature of the current account holder and has taken money from the account. So now, since Mrs. Greenwood has done this forgery, Mr. Greenwood didn't inform the bank. He didn't inform the bank. Now you see, it's a clearly breach of duty to disclose forgeries. There is a forgery. It comes to the customer's knowledge. Then the customer has a duty to inform the bank as the first instance, but he didn't. So it's a breach. Now, Mr. Greenwood advised Mrs. Greenwood not to do this thing again. So then he just kept quiet. He didn't inform the bank. And then the time passed. And again, Mr. Greenwood, after a certain period of time, he again checked his current account statement, then realized some money again has been taken from his account from issuing checks, by issuing checks. Then he knows who is doing this, so he again inquire from wife, and wife again admitted that he took again forged the signature of Mr. Greenwood and took money because she has to help her sister for medicine and other things. So what he did, she has taken money by forging the signature of her husband. So this time, Mr. Greenwood got annoyed, and he said that he is going to inform the bank. And meanwhile, Mrs. Greenwood committed suicide because of this reason. So then, after the death of Mrs. Greenwood, Mr. Greenwood claimed the money of or claimed the value of the checks from the bank, where the bank has paid. Then Mr. Greenwood filed action against the bank, claiming the money or the value of the checks, saying that those checks were, the signatures of the checks were forged. So therefore, the bank has no right to debit the customer's account. However, the court refused the argument or the claim of Mr. Greenwood, and it was decided Mr. Greenwood has breached the duty to disclose forgeries. So he had a duty he has a duty to inform the bank at the first instance when the forgery is discovered, but he didn't do so. Therefore, it is a clear breach of the duty. So therefore, Mr. Greenwood is not entitled for any compensation or any damages from the bank. So therefore, it was rejected. So this theory is known as Greenwood theory. So that is about disclosure of forgeries. So now we discuss two duties of the customer, main duties, that is Macmillan theory or the Macmillan duty, and the second one Greenwood duty or the Greenwood theory. So if you have any questions, any concerns, any clarifications you need with regard to Macmillan duty and the Greenwood duty, you can ask. Are you clear what is Macmillan duty and Greenwood duty? This is another important area for your exam also. Okay, if you don't have questions from this, then we'll go to the next one. Third one, the common question that we have: does the customer has a duty to check and reconcile his account? Now, in banks, when we are maintaining the accounts of the customer, we are used to send account statements to the customers. Current account, savings account, right? We send statements to the customers. But most of the time, monthly statements we send to the customers. So the question is whether the customer has a duty to check those account statements. If there is any error in the statement, whether the customer has a duty to inform the bank. So two questions now. One, if there is any duty cast upon the customer to check his statement. Number two, whether there is a duty cast upon the customer to inform the bank if there is any error in the transactions. So those questions were discussed in this case. Thai Hing Cotton Mills, Cotton versus Limited versus Liu Chong Hing Bank. This is known as Thai Hing Cotton Limited, Thai Hing Limited matter. So what happened here? An employee of the company over a period of time has forged the checks of the bank, checks of the customer company, and has taken money from the account of the company. And the bank has all this time sent the account statement to the bank, to the company, to the customer. But the customer has not observed any defects, any errors in the statements, and has not informed the bank with regard to any defects or any errors. So then then what happened? Once the company observed there is a forgery, forged. What they did, they sued the bank and claimed the money or the value of the forged checks. Then the bank argued that they said that we have sent account statement to the company. The company has not disputed those statements, and therefore they are bound by those statements, and they have accepted those statements are as correct. So therefore they now can't claim the value. So you may observe even the statement that some banks send to the customers, they have mentioned, or they have put clauses on the statement to say the bank, the customer has to go through the account statements, and if there is any discrepancy, any uh, any errors in the accounts, the customer has to inform the bank. So such a condition sometimes that we can observe in the account statement itself. Then the question is whether that is a duty cast upon the customer. In this matter, the court held, in the absence of express agreement to the contrary, the duty of care owned by the customer to his bank is in the operation of his current account is limited to the Macmillan duty and the Greenwood theory. So court said when if there is no agreement contrary, the customer's duty is limited only to the Macmillan duty and the Greenwood duty. The bank cannot impose further duties on the customer. So by putting a condition on the statement, the banker cannot impose further duties to the customer unless there is a contradictory agreement, separate agreement. So therefore, in other words, the customer has no duty to check his accounts and inform the bank. So the customer was under no duty to check his periodic bank statement so as to enable him to notify the bank of any unauthorized debit item. So it is not a duty of the bank, a duty of the customer to check his account and inform the bank. It is the duty of the bank to operate the customer's account as instructed by the customer, and also properly and correctly that bank has to maintain the account. So therefore, remember, it is not a duty of the customer to check his account statements or reconcile his account. So that is another important point. So there are two Sri Lankan cases also. There are many cases, but I have given here two important cases where they have in Sri Lanka also our court also has decided in the same manner, that is that the customer has no duty to reconcile his account. That was decided in particular Rubber Estate versus National Bank of India and that matter, and also Collatus versus Bank of Ceylon. In these two cases also, the court said in Sri Lankan court also said it is not a duty of the customer to check and reconcile his account. It is the duty of the bank. So that is another important point that we have to remember. Any questions from here? Okay, if you don't have a question from there, then we'll go to the next one, the classification of banker-customer relationship. So now the bank, under the banker-customer relationship, the duty of the banker, duty and the duties of the banker, rights of the banker we discuss. Then we discuss the customer's duties and rights and duties of under the banker-customer relationship. That part is over. Now we are going to discuss different types of relationship between the banker and the customer. There are different types of relationship between the banker and the customer. So the relationship between the banker and the customer can be broadly categorized into two categories. That is a general relationship and special relationship. So general relationship, what is a general relationship? The debtor and creditor relationship. Yes, any questions?
Hello, sir.
Yes.
Hello.
Yeah, yes. Please go ahead.
On the previous slide, sir.
Yes.
So if a customer does not check on his current account statements, uh, is bank can interpret that action as facilitate to a forgery, like, because if forgery goes in his account, if he does not check his statements, in a way it is a facilitation of a forgery type thing also.
No, no, it is not so. Now you see, uh, this one. You are going to go. You are talking about the Macmillan duty. So Macmillan duty very clearly says customer has a duty of reasonable care when he gives written orders or instructions. Right? It's apply only when customer gives written instructions or orders. That means when he is issuing checks or when he give instructions to the bank, he has a duty of reasonable care. Right? Now, when you come to this one, when you come to this here, right? But here customer doesn't give written instructions. Right? It is not applicable here because, as you said, if he doesn't check his current account, it could facilitate for a forgery. That is correct. But the Macmillan duty is not applicable here because the Macmillan duty very clearly says it's applicable only that when he gives instructions to the bank. Here the customer is not giving instructions to the bank. What has happened here? The bank sent statements to the customer. The customer has not observed or has not uh, uh, checked the account statement. So therefore, Macmillan theory will not apply here. It is, and also it is not a duty of the customer to check his account statement. And court very clearly says the bank cannot put that responsibility on the customer. It is the responsibility of the bank to maintain the account in a proper manner. So you can't shift the liability to the customer. Other than the Macmillan theory, other than the Greenwood duty, no other responsibility can be put into the customer unless there is a separate agreement. Is that clear?
Yes.
Okay. Any other questions? That's a good question. Any other questions that you have? Okay. If you don't have any other questions, then we'll go to this one. Okay. So the classification of banker-customer relationship, I think we will not be able to finish this. Now. We'll try. We have 15 minutes. We'll try cover some parts. Right? The general relationship, it's a debtor-creditor relationship. When a customer open an account with a bank, he fills and sign the account opening forms. By signing the forms, he entered into an agreement, contract with the bank. When the customer deposit money to his account, the bank becomes the debtor, the customer becomes the creditor. So what happened? When a customer open an account, customer after opening the account, customer can deposit money to the account. Once the money is deposited to the account, bank owe money to the customer. So the bank become the debtor, customer become the creditor. So it is under the general relationship between the banker and the customer. is a debtor and creditor relationship. On the other hand, the customer borrows the money from the bank, then he owes money to the bank. So customer borrow money from the bank, then he has to repay the money. So then in a situation like that, again it's a creditor-debtor relationship. The customer becomes the debtor, the bank becomes the creditor. So when a customer borrow money, that is the general relationship. Then we have special types of relationship under the banker-customer relationship. Number one, the bank as a trustee. So we have already discussed this part. The trustee is the holder of a property or on behalf of a beneficiary. The customer keeps certain valuables or securities with the bank for a safekeeping or deposit certain money for a specific purpose. The bank in such cases act as the trustee. The banks charge fee for the safekeeping valuables. So now, as we discussed previously, customers, they keep valuables with the bank if we have provided them safety locker facilities. Likewise, then the bank has to keep that property or the valuables in the custody of the bank on behalf of the customer. So bank in a situation like this has to act as the trustee of the customer. So therefore, the relationship, it's a special type of relationship under the banker-customer relationship. It's a special type of relationship where it's a trustee and the beneficiary relationship between the bank and the customer. So this is number one, the special type of relationship. Then we have a bailor and bailee relationship. This is again a special relationship between the banker and the customer. What is bailor and bailee relationship? There is a principle or the law principle called bailment. Bailment. So what is a bailment? Bailment is a delivery of goods by one person to another person for some purpose upon a contract. So bailment is a delivery of goods, the delivery of the possession of a good by one person to another person under a contract for a specific purpose. So that is called bailment. So here for the bailment, there has to be a delivery of good by one party to another party for a specific purpose. When the purpose is accomplished, the property to be returned to the person delivering the goods is called the bailor. Sorry, when the purpose is accomplished, the property is to be returned. So when the property under the bailment, if the property is handed over or delivered to a one person, when the purpose is over, purpose is accomplished, then the goods has to be returned. Good has to be returned. The person delivering the good is called the bailor. The person whom the goods are delivered is called the bailee. The person who got the property is called the bailor. The person to whom the goods are delivered is called the bailee. So that is called bailee and bailor and bailee. Special type of relationship. The banks obtain tangible securities. In some cases, physical possession of the securities, goods, valuables, bonds, etc. are taken while taking the physical possession of the securities. The bank becomes the bailee and the customer become bailor. Now, when we are lending money, in certain situation, the banks take tangible goods as a security. Tangible means that you can touch. It's a physical goods. So we take physical goods into our possession and we give credit or other facilities to the customer. For example, we can take gold articles into our possession and we can lend money on gold articles. So the bank get the possession of the goods. So once the goods are delivered to the bank becomes a bailee. The customer who delivered the goods to the bank is called the bailer. So between the bank and the customer, there is a special type of relationship which is called bailee and the bailer. So the goods were delivered to the bank for a purpose. What is the purpose? For a loan. Once the loan is paid, that means once the purpose is accomplished, the bank has to return the goods to the customer. Bank has to return the goods to the customer. So that is the nature of the bailment. So there is a different type or special type of relationship. There could be a different type of relationship between the banker and the customer based on the delivery of the possession of the goods or the securities to the bank when the bank is lending to the customer. So any questions from here? The bailer and the bailee relationship, or from the bank as a trustee? Okay, if you don't have any question from there, then we have another special type of relationship between the banker and the customer. That is a lessor and lessee relationship. A lease is a property. A lease is a property transfer of a right to enjoy such property for a period of time in consideration of price paid or promise. So what happened? A lease means that we give a property, the owner of the property give the property, the possession of the property to a third party on a rent. During the period of lease period, the lessee can enjoy the property, but he has to pay a rent for that period. That is called lessor and lessee. That has a lessor and lessee relationship. As we are aware, the banks today that we provide lease facilities to the customer. So under the finance lease agreement, that we can provide that lease properties to the customer. The customer enjoy the lease property during a period. During that period, that for the use of the property, the customer, the lessee, has to pay a rental to the bank, that is the lessor. So between the banker and the lessee or the customer under a lease agreement is called lessee and lessor, or lessor and lessee lease special type of relationship. Then agent and principal relationship we discussed before also, right? The bank, who is an agent? An agent is a person who acts for and on behalf of the principal under the express or implied authority, and the acts done within such authority are binding on his principal. Example, banks collect checks, bills, make payments to various authorities, telephone bills, insurance, premium on behalf of the customers. So then the bank acts as the agent of the customer and do certain activities for the customer. Because between the banker and the customer, there is a agent and principal relationship. As we discussed before, the bank is the agent and the customer is the principal in scenarios like this. Bank also abide by the standing instructions given by the customer. This is another occasion that the agent and principal relationship exists. When the customer give authority to the bank to do certain activities. In all such cases, the bank act as an agent of the customer, and charges for these services will be charged by the bank provide to the customer. So that is called agent and principal relationship. Then another relationship is there, that is as a custodian. The bank is a person who acts as a caretaker of something the bank takes the legal responsibility of the customer's securities, while open an account, the bank becomes a custodian of the money. So custodian means a person a custodian is a person who acts as a caretaker of something. So once the properties are delivered to the bank, or once the goods are delivered to the bank as a security, bank has a responsibility to take care of those items. So if it is perishable items, the bank has to be bank is responsible to maintain those goods in a appropriate manner. So as a caretaker, so therefore the bank, remember, once we get the goods into our hands, we are a custodian. Then as a guarantor, also there is another relationship. The banks give guarantees on behalf of the customers. We know that we issue bank guarantees in favor of the beneficiaries on request of our customer. So when we are providing bank guarantees, bank act as a guarantor. So guarantee is a contingent contract. So when that means that it's a secondary contract. When the bank guarantee is demanded by the beneficiary, the bank is liable to pay that money, and we have to abide by the demand, and we have to pay the bank guarantee. So the relationship between the customer and the bank now, it's a guarantee. Bank act as a guarantor, so the relationship is a guarantor relationship. It's again a special type of relationship. So that is about the different or special types of relationship between the banker and the customer. So then we have to discuss the termination of banker-customer relationship. Since the time is now 12:30, that is the time allocated for today's lesson. So we'll start this one on the next week. From here, the termination of banker-customer relationship. We'll start next week. Any questions up to now? Okay, if you don't have questions, then we will wrap up for today. So next week, it's a long weekend, and I have some commitments on family commitments, not confirmed yet. However, if I'm unable to come on the 16th, next Sunday, it's a long weekend, right?
Yes, sir.
So if I am unable to come, that I will let you know beforehand through the institution. Sometimes I might have to cancel the lecture, next Sunday lecture. So in that case, I don't know whether they will arrange some other lesson. Anyway, by Wednesday, I will let you know whether I will be able to come or not. Right. So thank you very much for the participation today. We'll start from the next topic, hopefully next week or week after that. That is 23rd. So thank you again. So please read your notes. If you have any questions, note down those questions, and you can ask those questions on the next day. Thank you. Thank you very much.